Hi, everyone. Welcome. We're just going to get started in a couple more minutes. Oh, hi. I'll go ahead and get started. Thank you, everybody, for joining us. This is the last in our HIV first responder series of webinars. Webinar 4 is going to be covering how to navigate the criminal legal system, specifically in the context of the criminalization of people living with HIV. If you have missed any of the other webinars in this series, they're all posted on the pwnusa.org website and are available to you. And I encourage you to go back through at any point to refresh yourselves on anything that we've covered before. All attendees are going to start on mute just to minimize background noise. But towards the end, we'll give you a chance to unmute so you can ask questions. And if at any point if a question occurs to you, you can also feel free to put that into the chat box, and I will read those out for our panelists at the end as well. Also at the end, you'll get the links to this recording, the links to all of these slides, and a link to an evaluation for this session. So all of that will be made available to you, so don't feel like you have to take notes of everything that you're going to see on the PowerPoint. Now, just a quick refresher about what the HIV First Responder Series is and why we're doing it. As most of you probably know, PWN and its chapters do a lot of work around legislative advocacy that is changing the laws, specifically that criminalize people living with HIV. But by creating this series, we really wanted a way for people to support and be advocates, even outside of the legislative advocacy realm. So how to provide direct intervention and on-the-ground support for people who have been criminalized. Our previous webinars covered doing intervention with the media, doing fundraising work, doing community organizing, and then this one is going to be the capstone that wraps up all of those and talks about doing specifically intervention with legal teams, doing education with the main players of the criminal justice system, and includes an in-depth look at the way the criminal justice system works as part of that. So I have the honor of introducing our two panelists today. Our first panelist is Mayo Schreiber Jr. He is the Deputy Director at the Center for HIV Law and Policy, also known as CHLP, based in New York. The CHLP is a national legal and policy resource and strategy center working to reduce the impact of HIV on vulnerable and marginalized communities and to secure the human rights of people affected by HIV. He is a federal criminal defense attorney with 25 years of experience in private practice. Previously, he was a pro se law clerk at the United States Court of Appeals for the Second Circuit. He was also a monitor to the Honorable William Wayne Justice, Chief Judge of the United States District Court of the Eastern District of Texas in the case Ruiz versus McCotter, a case involving confinement conditions for all prisoners incarcerated by the state of Texas. Our second panelist is Monique D. Howell. She was born in Fort Sill, Oklahoma, and traveled all across the world because her parents were in the military. After she graduated high school, she also served in the U.S. Army, where she was an administrator clerk. She is now a proud mother of 4 children, one of whom she just recently adopted. She is also an author of her first book, entitled Living Inside My Skin of Silence. She is a motivational speaker and an advocate that works on HIV/AIDS awareness and HIV criminalization. She is also part of the PWN South Carolina Committee and appears in the documentary film HIV is Not a Crime, along with others, and sharing their testimonials of how they overcame the many challenges that came with HIV criminalization and the strength she gained by those many challenges. So welcome to both of you. All right, let's go ahead and get started. So Mayo is going to give us an in-depth look at the criminal legal system, starting with who the players are, common terms that are used. I'll hand it over to you.
Hi, everybody. This is Mayo. I'm really delighted to be with you. Thanks to Rebecca and the Positive Women's Network for inviting me and giving me this opportunity. I'll start out by talking about some of the main players in criminal law in a court case, and then I'll just talk a little bit about how a case proceeds, and then I can give you some just general terms that are used in the law. When we have questions, please ask me anything. There are no wrong questions. The criminal legal system can be very confusing, particularly if you have no experience with it. So why don't we start out? The first person in a case really is what they call the complainant, and that's the person who feels as though they have been wronged under the law, that they're victim of a crime. So, for example, if we'll use me as an example. If as a person living with HIV, if I went to, say, a bar and went home with somebody, and I was living in a state where there was requirement to disclose my status before engaging in sex, and the person I went home with and I had sex, and later the person felt that I hadn't disclosed, they could go to the police and describe what happened, what they believed happened to them. That person would be the complainant. Sometimes they're called the victim. I would be the defendant. I'm the person who would be accused of violating the law. The next party would be law enforcement. So when a complainant goes and talks about what they believe happened to them, they would, for example, they could go to a police station and talk with an officer about what they believed happened. The police then would, they might take out a written statement, and then they start to gather evidence about what happened. They'd want to talk to other people. They may want to talk to, for example, the example I gave you, they may want to talk to other people who were at the bar that night, the bartender. They may want to talk to friends of mine or the complainant. They'd gather all the information about the alleged crime in the case. They're responsible for preserving this evidence if it goes to trial. And also, if they want to, they can arrest the defendant. The next person involved is the prosecutor. This is an attorney. They don't represent the complainant or the victim. They are representing the state. They're frequently called, for example, an assistant district attorney. And they represent the interests of the government. They want to make sure that if a law, most typically in HIV criminal exposure cases, they're state-based, the law in that state, they believe it's been violated, they want to prosecute the person, the defendant, who they believe has committed that crime. They're the ones, they're the really the legal end of the case. They initiate it in court. They review the evidence presented to them by the police. When the case is at trial, they're the ones who prove to the judge or to the jury whether or not a crime has been committed. They also have the authority to engage in a plea bargain. They can also drop the case if they feel that that would be in the interest of justice. They have a really enormous amount of authority. It's also just important to think about that authority includes the ability to have investigators dig up information about the case. They have, media people to present the case, contact newspapers, television. That is very different than a defendant has. The defendant, their attorney usually doesn't have the same sort of deep pockets. The defendant hires a different attorney. That would be a defense attorney, a defense counsel. And they're the ones that would represent the defendant against the claims that the state is making, the charges. You can, a defense counsel can either be privately retained, and that's if you have the money, you can enter into a retainer agreement with a lawyer and they will represent you. If you're without funds, the court is obligated to either appoint a lawyer to defend you, or you can be represented by the Office of the Public Defender. Defense attorneys have some rigorous obligations. They've got to do the best they can in terms of defending you. They've got to tell you about everything they know about the case, all the facts, and they've got to work to obtain the best possible outcome. They need to tell you this information because as a defendant, you may want to enter into a plea agreement. You may want the lawyer to try to get the prosecutor to drop the case. It's really important to understand that they're working for you as a defendant. And so it's their obligation to tell you about the different types of defenses you have, about what type of sentence you might receive, and what other penalties you might be facing if you are convicted. For example, in, I think it's about 6 states, if you are convicted of an HIV exposure crime, you can be obligated to register as a sex offender. So any related criminal actions connected to your case, they need to tell you about that. And you need to know, you can ask them about those, any questions you have. You need to be really well informed. There are all kinds of defense counsel. There are, good ones and bad ones. The type of, the quality of the lawyer really doesn't depend on whether they're a public defender or whether they're in private practice. There are many superb public defenders, and there are some poor privately retained attorneys. It really has nothing to do with how they're employed. Your case, once the case is initiated by the prosecution, that will be in the court. I'm sure you're all familiar with that. That's the state institution where that holds the case, and that's in a courthouse. That's where the legal issues relating to the case are heard, where the trial will occur, and where a defendant will be sentenced. And in most states, there are various levels of, all states are various levels of state courts. There's the trial court. There's usually, and then there's courts that are higher up. There's an appellate court that can decide if you decide to appeal your case, that'll be the court that'll hear the case. Finally, there's a Supreme Court. You should know, though, that further you go up in terms of the level of a court, the fewer the cases are heard by a court. And all cases don't automatically are appealed to appellate court or present a question for a Supreme Court. Where the case is heard, which court it is, depends on the jurisdiction. And that means just normally, I'm based in New York, so if I was alleged to have committed a crime, the case would be here in New York City. Normally, the cases, the trial occurs where the crime occurred. Finally, there's the judge. The judge is in charge of the case. They want to make sure that the law is applied correctly, that all the procedures and rules are applied. They oversee everything that happens in a case. They have enormous power. Technically, they're supposed to be blind. You've heard the expression justice is blind, and that means they're supposed to be impartial. So they're not supposed to have any preconceptions about the defendants that appear before them. Mostly in cases, there's sort of two parts to cases. There's the facts, and then there's the law in the case. And the facts come up through documentary evidence or through testimony at a trial. And the jury, if there is a jury in the case, they're the ones that decide what the facts are. The judge will tell them how to apply the law. The judge hears motions about whether certain evidence should be excluded or not, and about which witnesses should be allowed to testify. The jury is a group of people from the local community that are chosen to sit on a case. The number of jurors depends on what state you're in, on what the particular laws are, and they're the ones that generally decide the facts in the case. They're not lawyers generally, so they're not telling, they're not deciding how the law in the case is applied, but they're deciding the facts. Whether, for example, whether I did indeed go to a bar the other night when I met with the complainant, whether I took the complainant home, whether or not I disclosed. They're the ones that make those decisions about the facts in the case. And then they're also, at the end of the day, they're the ones that decide whether or not the defendant has violated the law. They will do that, and then the judge will be the one that will sentence them. Those are roughly the main players in a criminal case on the state level. I can talk briefly about just how this all flows, but does anybody want to have, are there any questions before I proceed about any of these players?
Yeah, if you have any questions, you can raise your hand in the Q&A box and I can unmute you, or you can type your questions directly into the chat box. Okay, I think we're good to keep going.
Okay, so I'll just give you a brief sort of a flow chart of how this works. So we'll go back to the example, you know, the other night I went to a bar to meet somebody. That's the incident that sort of is the base of the case. Once I've had that interaction and, for example, the complainant, the person I met, feels that, for example, I didn't advise them that I was HIV positive, as I said before, they go to the police station, they make a report, they file a complaint, it's frequently called. They talk to the police about what happened. They're available to the police for any questions that come up during the investigation. The police investigate the matter. They talk to, as I said before, witnesses in the case. They gather up any other information they can about it, and then they turn it over to the prosecutor. If the the prosecutor thinks there's enough information there for an arrest for a case, that person will be, the defendant is told to appear at court at a certain time, and they'll be arraigned. Arraignment is very important. That's when the defendant is told what charges they're facing, what charges, if it's an HIV exposure crime, if it's in a state that doesn't have a specific, for example, HIV criminal statute, same sort of issue, they could be charged with assault in some states. That's where you first formally learn what charges you're facing. You'll enter, the defendant or his lawyer will enter on his or her behalf, will enter a plea of guilty or not guilty. At that time, and this is very important, the judge will decide whether or not you should be granted bail. This is incredibly important for several reasons. If you always want to be granted bail because that allows you to be out and about, to be working, to be with your family, and to help the lawyer prepare for the case. If you're not granted bail and you're sitting in jail, in prison, it's much harder for a lawyer to work with you about your case. There's complicated security procedures or telephone calls in terms of them meeting with you, going over documents, talking about different aspects of the case. The judges, when they decide whether or not to grant bail, they look at a number of things. They want to know, are you going to show up for the trial? Is there any chance that you would flee? And so they can set bail at a certain amount. Some cases it can be quite high. If the judge thinks you're going to, there's a chance that you would flee, they could set a very high dollar amount, for example, $100,000. The judge would get to decide whether you have to post the $100,000 or somebody close to you could, or they'll take a percentage of it, for example, 10%. Once that's taken care of, the next part of the case is the actual trial. That's where you're represented by your defense counsel. The state is represented by the prosecutor. It's where witnesses are called and the case is actually presented. In any criminal trial, the defendant does not have to testify. It's their right to remain silent. During the trial, the prosecutor has to prove that you've violated the law. Before you go to trial, frequently there's a chance for a plea bargain. Most cases in the United States do not go to trial. An overwhelming percentage of them are dealt with by a plea bargain. There are a lot of reasons why defendants may want to engage, or the prosecutor may want to have a plea bargain. Frequently for a defendant, instead of being charged with, for example, a felony felony where a very serious criminal offense where you might have to serve many years in prison, you could agree to plead guilty to a misdemeanor, which generally means less than a year in jail. The prosecutor may think, I don't really have a great case here, so I'd be interested in entering into this agreement. And the defendant may want to do it because they're going to get a less serious charge. So after either the trial occurs, where a jury finds you guilty or not guilty, or whether there's a plea bargain, if you've been found guilty in a trial, or you've entered into a plea bargain, at that point, the judge, once you're convicted, the judge will sentence you to a certain amount of time in jail. The judge can, for example, if you're a first-time offender and the judge doesn't think it was that serious a crime, depending on what the law says, the statute, the judge can sentence you to probation in some instances. In some states, there's a very specific time they have to sentence you. It really goes state by state. So that's generally an overview of how a criminal prosecution works. There are a bunch of legal terms. I'm not going to read them or talk about them, but if there are any questions, I'm happy to answer any questions about that. I think, I know the group will be particularly interested in talking about two topics, but I'll hold off on that. There are a lot of privacy issues in prosecutions, both depending on the state for the defendant, and there's also advocacy issues that are connected to those privacy issues. But perhaps we can talk more about that after there are any questions or after Monique talks and shares with you her observations.
Thank you. We did actually have a question in the chat. So in the example you used was, a situation where there is a non-disclosure law on the books. So the question is around what does it look like in the criminal justice process for states that don't have HIV-specific laws but may nonetheless try to charge people under general criminal laws?
That's a great question. There are about 34 states approximately that have HIV-specific laws in the country. Other states do not, and in those states, you can be prosecuted, for example, assault or endangerment. So in Texas, there used to be an HIV-specific law, but the legislature changed that, got rid of that, but now in Texas, if, for example, you have, if you're positive and you have sex with somebody and they say that you transmitted HIV to them or you did not disclose, the state can charge you under their general laws, for example, assault. And that happens fairly frequently, for example, in Texas.
Great, thank you. And I'll pause again to see if there are any other questions. Okay, Monique, we'll move into your piece.
Hello?
Yes, we can hear you.
Okay. So with my piece, it's a little testimonial, pretty much how everything happened. First, I want to go through the slides, prosecution outcomes, which includes media, sensational of loss of privacy, with prosecution also felony convictions, up to 30 years in prison. You can become sex offender, difficulty finding employment, housing, threat of losing your children, loss of rights to vote, travel, even to choose where you live from. And also you can be a threat to violence, domestic violence, and any different types of relationship type violence. And one thing I think would be good is starting a statewide campaign, identifying your goals with the laws, like maybe changing the legislation, protect against new legislation, educate lawyers and judges, educate in the police, training the media. Just education overall is very important when starting a statewide campaign. And also another piece with the statewide campaign is, like I said, finding your legislation champion. Determine what committee the bill will assign to, and talk with that chairman, talk with the chairperson about what can be changed in that state with the laws and know your legislative staff, legislative assistant, and the party staffers.
Thank you. And then could you go ahead and share, to the extent that you're comfortable, your experience with criminalization?
My experience with criminalization overall, being criminalized because of non-disclosure hit home for me because first, I wasn't even educated about HIV criminalization when I was charged. I believe had I was educated and had everyone that was the defender, me as the defender, the lawyers, everyone that was in the courtroom, had all of us was properly educated, I think things would have been handled a little bit different in my case. But because because of non-disclosure, of course, I was put on trial. I felt that that my privacy was also invaded because how everything was handled, how, you know, different ones knew that I was HIV positive. I believe that, you know, my privacy right there escalated when it should not have got escalated the way it did. I believe the laws need to be changed. I believe when I was on trial, they had outdated laws. They didn't really kind of know where to like, they didn't know what to do with me pretty much. It was kind of a back and forth battle with me. If convicted, I was going to be looking at 8 to 12 years. They did not really kind of tell me why I would have, all they knew that I was HIV positive. They didn't really go into details of, you know, why they really wanted to convict me. I had to get out of my home. I had 3 children that had to be taken away from me during trial. They interviewed many of my family and my friends. Once again, I think my privacy right there was also invaded because I was not public about my HIV status, but because word got out that I did not disclose with the other partner, they just started grabbing people from left and right, interviewing them, making them testify against me. Nobody knew why they were pretty much being testified. They didn't know why they were taking the stand. So it was kind of like nobody knew what to do. So I really believe that educational piece is so important when we're taking the stand. And to me, the laws, it's not based off of science. It doesn't reflect the actual HIV transmission. Fewer than 10%, you know, even transmit the virus. 25% of the behaviors, there's not even related to HIV. So prosecution, to me, the outcome of prosecution, we would have to deal with the media, something that I was not ready for. The felony convictions, being, you know, possibly being convicted of 30 or more years in prison, that could have happened to me. I could have been a sex offender. Thank God I did not become a sex offender, but there's many cases that are. My job, I was in the military when this all happened to me. So the laws, even with being prosecuted in the military, is different than not being in the Army. The threat of losing my children could have been at stake. I did not know whether I was going to be able to even continue to raise my kids, all because of a non-disclosure. And just losing different rights that we all have now, the right to vote and the right to do other things. I was at stake of losing all of that if I was convicted. So I was pretty much on trial, not knowing, I didn't know anything. I didn't even know what a public defender was. You know, it was more like Mayo said, facts, getting the facts and knowing the law. I was confused I think they were confused at getting the facts versus, you know, dissecting the facts and the laws. Like, what is facts and what are the laws? Nobody knew anything. It was more like Monique, you know, Monique is HIV positive. She didn't disclose, you know, what can we do to prosecute her? What can we do? And nobody knew nothing. So now that I'm educated about HIV criminalization, I felt that in each state is so important to get that educational piece. It's so important to update people about what we need to do in our communities and get with, you know, the community, get with the PFLAG groups and get with the churches, the ASOs, and get with the pride events, educational forums, social groups, health departments, and educate one another about HIV criminalization laws. That way, when things like this happen, everyone's on the same page, and we can make the right decisions and not just throw people under, in a jail and said, hey, you deserve to be charged because you didn't share your status or because you're HIV positive. We all need to get on the same page with these laws so that we can be fair with the person that is being charged.
Thank you for sharing. So based off of all of that, I do want to bring it back to Mayo. It seems like there's a lot of serious consequences that come from being charged under these laws. There's clearly often this inequitable power dynamic between people in the criminal justice system and the person living with HIV who has been charged. And a lot of that may be that on both sides, there's a lack of information for the person who has been charged on their rights and on the science around what they're being charged for. And on the side of the criminal legal system, a lot of misinformation and misunderstanding about what it really means when they're criminalizing somebody based on their status. So, recognizing that, what would you suggest for folks who, whether or not they are themselves a person living with HIV, how would you suggest people do advocacy in this area? Both the people who have been charged and with the legal team and legal professionals that they're dealing with.
Those are really good points, Rebecca, and Monica, your testimony is really powerful. I just want to touch a little bit about some of the hard choices or impossible choices that Monique had to make. In terms of advocacy, statewide advocacy, Monique is absolutely right. That's key in terms of legal education and advocacy to change the laws. But also advocates should be, when they're involved in this work, they have to be very sensitive, very respectful of defendants' choices about media. So if you're working with an HIV advocacy group and you hear about a case in your area, before you start advocating on behalf of the defendant, you really need to find out through the defendant's lawyer what the defendant, what their personal choices are. Some people really don't want the publicity about the allegations about their status. They may not be out about their status to their family, their friends, on their jobs. Other people, they may feel that they've been deeply wronged and that they're in a place where they can deal with media attention, and so they would appreciate advocacy in connection with their case. But that choice always has to be the choice of the defendant. And also, it's really the lawyer has to be involved, because there are some cases where there's been no media coverage, for example, about the case, and the lawyer would prefer to keep it that way because the lawyer may be able to get a better outcome for his or her client if there's not a lot of media attention. This may be particularly true. Some states, the prosecutor, the lead prosecutor, or the judge is in an elected position. And if you're in an extremely conservative area, those players, the judge or the prosecutor, may feel like they need to make an example out of the defendant. And so I would really encourage advocates to speak with the lawyers, find out what, in terms of an individual case, what the defendant and what the lawyer, what type of assistance they would like, whether that involves, a letter writing campaign, whether that involves, media coverage, or not. But that's something that really, that's the choice of the defendant.
Thank you. And then my follow-up question was, assuming that they've gotten the permission of the person they're advocating with, and they're working closely with the defense attorney. Is there a best or most direct route for advocacy in terms of who to speak to? I know you highlighted prosecutors and judges as being two parties who have a lot of discretion. Would you say generally one is more preferable over the other when it comes to doing direct advocacy or education? And is advocacy with prosecutors and judges generally effective, in your opinion?
It is. There are different types of advocacy. In terms of in an individual case, the advocacy most of the advocacy is going to be done. A lot of the advocacy is going to be done by the defense lawyer. So the defense lawyer needs to, in preliminary motions in a case or in discussions with the prosecutor, make sure that the most up-to-date information about HIV is shared. A lot of prosecutors, a lot of lawyers just don't know much about HIV. So it's very important that they understand that, for example, you can't transmit by spitting or biting somebody, and that even the transmission rates for different types of sexual activity are extremely low. That's really an important part of a defense attorney's job, to make sure that the prosecutor knows, is informed about HIV. That will impact how they will handle the case. It's the same thing with the judge. Some judges just have no idea. So when a lawyer is representing a client, they will want to make sure that that information gets in front of the judge, whether it's in a request for example, money for an expert witness. You will want to let the court know why these things are so important. So part of a lawyer's job is to educate the prosecutor and the judge in the case. But to step back from that, there are also, for example, Center, we have meetings or conferences with prosecutors to make sure that they know the most recent information about HIV. That's also really important. And then also just, advocacy and getting the information in the media, and for it to be covered in a scientific, straightforward way is incredibly important to educate everybody in the community.
Great, thank you. And then I will turn it back now to Monique. As somebody who's survived criminalization, who's highlighted a lot of issues around misinformation, lack of information, what would you suggest for folks who are wanting to provide support for people who have been criminalized? What are what is advice that you most want people to walk away from? Walk away with?
What I would want people to walk away with is, we need to educate. It's all about, to me, it's all about educating. I mean, we need to educate one another about these laws, so that we can share the information to get these laws changed and to stand with those who are being convicted, stand with those who are being criminalized. Develop talking points, for the public health, and develop the strong advocacy so that we can know what to say when we have to stand, for those who are being criminalized in the courthouse, so we know exactly what we're saying, how we're saying it, versus facts against laws.
Thank you. I will open it up now to questions. Once again, you can raise your hand in the Q&A box and I can unmute you, or you can type them directly into the chat box. Okay, great. I want to thank Mayo and Monique again for being our panelists. That was great information. Would it be all right to include your contact info in the email I send out in case people have more questions for you?
Yes.
Sure. Rebecca, may I say one more thing?
Yes, absolutely. Go right ahead.
I just, in terms of advocacy work by folks, it's really important that you know the law in your state. That's key in terms of what type of activity is prohibited or what's prescribed. I'd also, we've been talking about some privacy issues in terms of like the lack of privacy that Monique felt. Some states, for example, in California, just passed a new law this year. And in that state, there's some strong privacy protections for complainants and for defendants. So when you're doing your advocacy work, you need to know the law in your state, and you need to look to other states where the laws might be better, or other organizations, whether it's CHLP or the Positive Women's Network, and thinking about how you might want to change the laws to make them more fair to folks and more scientifically and medically current.
Thank you. And we did get 2 questions in the meantime. So the first one is, when somebody has been charged for a crime not related to their status, how does a defendant keep from having to disclose their status to the judge and prosecutor? If I'm reading that question right, I'm sorry if I'm not, feel free to clarify. So based on my understanding, okay, great. So based on my understanding, when somebody's been charged with a crime not related to their status, how do they keep their status from the judge and prosecutor? Are there kind of confidentiality, privacy protections in place there?
There are. That's a great question. It depends on the state. Some states, health departments have different obligations whether or not to help the prosecution. If it's totally unrelated to the alleged crime, it's up to the defendant to make a motion in court to keep that information from being considered in a case or discussed in a case.
Thank you. And then the other question was, how do people find attorneys that are familiar with HIV-related criminalization based on status-related issues?
That's a good question. You can contact, we can't refer people to specific attorneys, but we can help you identify attorneys in your jurisdiction who might have some familiarity with the issues. You can also go to organizations, local bar associations, where they may be able to help you out with that, or organizations, for example, the National Association of Criminal Defenders. There are a variety of organizations that may give you some leads in terms of finding a private attorney who is knowledgeable about these issues.
Great, thank you. Were there any more questions? And Monique, did you have any other thoughts you wanted to share?
No, I don't.
Great, thank you. All right. So just to sum up, right after this webinar ends, I will email out this complete PowerPoint so you can refer to these. And I will also send out the recording for the session for your review. And also with that is an evaluation for this webinar. Please do fill that out. This is a new webinar series we've launched, so we'd love any feedback. With that, I'll close it out. Thank you everybody for attending. Thank you to our panelists. Oh, was there one more question? Okay, great. Thank you. Thank you everybody, and have a good day.
Thank you everybody.